Hello and welcome to another video case report, this time covering the case of John Doyle Construction Limited and Erith Contractors Limited, a judgment handed down by the Court of Appeal a few weeks ago. Now this involves claims arising out of the Olympic development. You might recall that BAM was the management contractor, but Erith were awarded the groundworks package and John Doyle were their subcontractor dealing with various landscaping works. Now, the works actually reached completion after the Olympics in 2013, but before they did, John Doyle went into liquidation. So the final account dispute involved not just the claims from John Doyle for sums due pursuant to the agreement, but also the cross-claims, the counterclaims raised by Erith for the cost of having to complete the works. Now, the liquidator didn't actually resolve those claims in the liquidation. Instead, they sold them to a third-party claims consultant. Now, it wasn't until 2018 that adjudication proceedings were actually started, and at the conclusion of that, the adjudicator awarded John Doyle £1.2 million. There was another 2 years before there were any enforcement proceedings, a period in which no doubt there were negotiations, partly over the security that Erith demanded if, having paid the £1.2 million over, they pursued a final resolution of the claim, and a proportion of that 1.2 million had to be returned. Now, in the first instance decision, Mr. Justice Fraser held that the security that had been offered was insufficient, and summary judgment was refused. John Doyle appealed that finding, and what we get here in the Court of Appeal judgment, it doesn't just address the principle of the adequacy of security, but also considers the circumstances in which an insolvent company can enforce an adjudicator's award in light of the Supreme Court's judgment in Brexco. Now, there are 2 points of principle to take out of this case. The first concerns about how adjudication and insolvency work together, and also the points about the security, but in particular the way that the case was brought by the claimant and what we can learn in terms of the process and procedure that comes out of this judgment. So first, turning to the issues of adjudication and insolvency. Well, the starting point for us all is what is now quite an old decision of Bouygues and Dahl Jensen, and we need to go down to paragraph 85 to find the relevant extract here. But the principle that comes out of Bouygues is that where you have claims and cross-claims, and that's what we're really dealing with here, a situation where an insolvent company has a series of claims, but the solvent company against it has cross-claims. So limited to that principle, it's important to bear that in mind. But where you have that situation, an insolvent company cannot generally enforce. And the reason for that, at least the reason stated in Bouygues, is extracted here. If Bouygues was obliged to pay Dahl Jensen the amount awarded by the adjudicator, those monies, when received by the liquidator, will form part of the fund applicable for distribution amongst the creditors. If Bouygues itself has a claim under the construction contract, as it currently asserts, and is required to prove for that claim in the liquidation, it will receive only a dividend pro rata to the amount of its claim. It will be deprived of the benefit of treating Dahl Jensen's claim under the adjudicator's determination as security for its own cross-claim. So the principle that comes out of this, or certainly the discussion amongst us as practitioners, was, well, if it's right that adjudication by an insolvent company in these circumstances is basically futile, you can't enforce that award, why can't you take out an injunction to prevent the adjudication from going ahead in the first place? And that's the principle that the Supreme Court considered in Brexco. And in effect, in reality, what Lord Briggs held in the Supreme Court decision was that although you can injunct a party from breaching a contract, you can't injunct them from exercising a contractual right. And he puts it this way. The insolvent company has both a statutory and a contractual right to pursue adjudication as a means of achieving resolution of any dispute arising under a construction contract to which it's a party, even though that dispute relates to a claim which is affected by insolvency set-off. So what's going on here? On the one hand, an insolvent party can adjudicate an issue, but it's got no teeth. What's the point of that? Well, in reality, the best way to think about it is that what we have here is two spheres of law coming into contact and having to reconcile themselves. On the one hand, you've got us as construction professionals wanting to have an effective adjudication, and the only way that we think we can have an effective adjudication is if it has the teeth of enforcement that back it up. On the other hand, you've got insolvency practitioners that think about the world in a completely different way. And in order to, because ultimately what the result of all this jurisprudence is that insolvency rules trump any principles of adjudication, we have to try and put on this unfamiliar insolvency hat in order to understand what's going on. And let me do my best to try and explain what that is. Under the insolvency principles, where there's a claim and a cross-claim, the liquidator is only entitled to enforce the net position. So it's only once you've resolved both the claim and the counterclaim that the entitlement that the liquidated, the party in liquidation has any entitlement at all to any money, assuming that the net position is in its favour. Lord Justice Lewison puts it in this way at paragraph 129 of his judgment. This is how he summarises the principle. And the principle is this principle of insolvency set-off. It's automatic or self-executing, as it's sometimes called. It affects the substantive rights of the parties and will reduce or extinguish a debt. The claims exist for the purposes of quantification only. When it comes either to proving in the insolvency or suing in court, it's only the net balance which can be proved or recovered. If claim and cross-claim are both litigated, and the cross-claim amounts to a set-off, the latter overtops the former, then judgment on the claim must be entered against the claimant and in favour of the cross-claimant. It is wrong in principle to enter judgment separately on both claim and cross-claim. So, put it another way, there is no room here for an interim decision on a claim before then dealing with the cross-claim. So that's why the principles of insolvency are offended by the principle of adjudication and enforcement in these circumstances where you have claim and cross-claim. So what Brexco does is it acknowledges the liquidator, in performing his functions or its functions, has a wide-ranging power to determine that net position. So when you get to paragraph 132 and 133, which involves extracts from Lord Briggs' judgments in the Supreme Court, he held, within the liquidation, a net balance owing to the creditor must be pursued by proof of debt in the ordinary way. The liquidator is entitled to be paid the full amount of any net balance owing by the creditor and may exercise any available remedies for its quantification and recovery, including litigation, arbitration, or ADR. If there's no dispute as to the existence and matter of the claims and cross-claims, this is in practice a matter of simple arithmetic, the net balance being the difference between the aggregate of the claims and the aggregate of the cross-claims. But if any of the claims and cross-claims are in dispute, then those disputes will need first to be resolved by reference to the individual merits of each before the arithmetic resumes. So here, the Supreme Court says, well, there must be value, with your insolvency hat on, there must be value in a liquidator using his power, his contractual statutory power, to adjudicate in the effort to find that final position. And it's irrelevant whether or not you can enforce or not enforce, because it's a legitimate contractual or statutory right that may ultimately help help us to reach that final position. But what the Court of Appeal are doing in this case, both Lord Justice Coulson and Lord Justice Lewison are doing in this judgment, is to clarify that the Supreme Court decision in Brexco would not be interpreted as a green light for enforcement of adjudicators' awards, somehow circumventing the insolvency rules. Just because you can adjudicate doesn't mean that you get the teeth of enforcement that come with it. Now, both Coulson and Lewison put it in different ways, but I'll highlight Lewison's ratio in paragraphs 145 to 145 and 153. In the first place, if the liquidator is only entitled to sue for the balance, it's difficult to see how it's possible for a court to give judgment for a larger sum. Put simply, it goes beyond the company's entitlement. Second, to give judgment for a larger sum than the net balance amounts, in effect, to the disapplication of the statutory insolvency scheme. As I've said, the statutory scheme is not discretionary, and even contract cannot override it. There seems to be a debate in construction circles about whether the enforcement of an adjudicator's award is the enforcement of an underlying contractual obligation under the construction contract, or is the enforcement of an express or implied term to comply with the award itself. But whichever of those views is correct, neither imbues an adjudicator's award with some elevated legal status. It is true that the adjudicator's decision is provisionally binding, but I cannot see a relevant distinction between that situation and one in which a fixed payment is due under a contract which is definitively binding. In his conclusion, as clear as he can put it, as Lord Briggs pointed out, there's considerable procedural flexibility in the conduct of a liquidation. The flexibility should be used to ascertain the net balance one way or the other. In my judgment, it's only once the net balance has been ascertained by whatever are the appropriate means that judgment should be entered. So in those circumstances where you have claim and cross-claim, you should not expect to be able to enforce an adjudicator's decision where the enforcing party is insolvent. Well, what about the procedural point? Well, this all centred around what security would be sufficient to protect Erith if the enforcement was granted. And the key to this section is the background that I've already gone over. It was a very stale claim. The claim was sold to a claims consultancy, a situation that might have been considered champetous. And the way in which the claim was prosecuted seemed to be by spending as little as possible in the hope of a quick win. But to make matters worse, the enforcement proceedings themselves were brought in a number of years after even the adjudication, and they were brought in what both the court in first instance and the Court of Appeal considered a haphazard, unfocused and aggressive manner. What actually emerges from the chronology when you read it is that John Doyle was being quite heavy-handed, brought proceedings really as a way to try to put even more pressure onto Erith, and ultimately ended up, because the proceedings went ahead, trying to perfect its offer of security through correspondence submission, even oral submission at first instance. And on appeal, they were trying to piece together adequate security by picking out bits and pieces of submission, even from the transcript at first instance. Now, Lord Justice Coulson took a very dim view of this, I think it's fair to say, and at paragraphs 31 and 32, really that's where you get the guidance from Lord Justice Coulson that I think is relevant to us as practitioners to bear in mind. It's important that a claimant company in liquidation seeking summarily to enforce an adjudicator's decision should take all necessary steps to ensure that the hearing itself is as efficient as possible, and that it's clear to everyone what issues the judge is being asked to decide. Brexco stated that the potentially complex issues that can arise between the parties where the claimant is in liquidation were for the court to sort out at enforcement stage. As this case again shows, that burden is not to be underestimated. The least the claimant can do is make its own position crystal clear. In particular, any undertakings or security being offered by a claimant company in liquidation need to be clear, evidenced and unequivocal. It is not for the judge to point out during the hearing potential inadequacies with the security offered in order to give the claimant an opportunity to amend its offer on the hoof in the hope of making it more acceptable. Neither is it for the judge to endeavour to turn vague suggestions by counsel in the cut and thrust of oral argument into a potentially binding agreement between the parties, or to try to tease out of the material before the court whether some other offer could or might have been made instead, and if so, what its hypothetical consequences might be. Such an approach gives rise to confusion and potential injustice. If a claimant wants to summarily enforce the adjudicator's decision, notwithstanding its own liquidation, it needs to be unequivocal about any offer that it's making to ring-fence that money or otherwise to protect it. Where there is a dispute about the sufficiency of the undertakings or security on offer, it must at least be beyond argument what has been offered and why. Now, you can read the rest of the judgment of Lord Justice Coulson to further understand the particular shortcomings of the security that was offered and the various options that had been gone through. But the key takeaway in terms of practice and procedure here is whatever negotiating practice you want to employ, however commercially you want to try to exert pressure on the other side, ultimately, if you take the step to litigate, you need to make sure that you are setting out a clear and concise case that passes the necessary test. That's the point to drop the commercial pressure approach and to adopt a robust and clear case that, again, complies with the relevant test that you're trying to pass. Thank you for listening. I hope you enjoyed it. If you did, please like it and share it, and I'll see you next time.